Hi, hello. Before we start, we'd like to wait a couple of minutes, about 2 more minutes, to start the presentation. So if you could just bear with us, we're just waiting for everybody to log in. Okay, Samuel and Anna, should we start now?
Yeah.
Okay, great. Okay, before we start, I'd like to make sure that you can hear us. If you could please raise your hand on the GoToWebinar panel to let me know if you can hear. Okay, great. Thank you for doing that. Welcome and thank you for joining us today for today's webinar on past performance, how to use yours, benefit with others, and defend it from attacks. My name is Edna Sergio and I work at Virginia PTAC. We are a sponsored program of George Mason University and funded in part through a cooperative agreement with the Defense Logistics Agency. If you're a Virginia-based business, please sign up to be a client and take advantage of the free one-on-one counseling service that we offer. We also have the BidMesh subscription service that is available to all our clients. If you're interested, you can take a look at the sample profile on our website. If your business is based outside of Virginia, please take advantage of your local Procurement Technical Assistance Center by finding your local office at the Association of Procurement Technical Assistance Center website. Before we start, I'd like to mention a couple of things. The slides will be available on our website after the webinar on the e-center where you signed up for this class. This webinar is being recorded. You will, when you have any questions during the presentation, please type them on the question window box, not the chat box. And if we run out of time during the Q&A, we'll get back to you and after the webinar. If you're joining us by phone only and could not see the screen, please make sure to email us at ptac@gmu.edu so I can document your attendance. But if you can see the slide presentation on your computer or smartphone, you do not need to email us. I will be taking attendance during the session. At the end of the webinar, I will be emailing you an evaluation survey. Please make sure to fill the survey for us, and it's important to your instructor as well. Our instructor today is Samuel Finnerty and Anna Sullivan. Samuel Finnerty is an associate attorney at Pilerio Massa, who represent clients with a wide range of government contracting and litigation matters. His experience includes representing federal contracts in bid protest before the Government Accountability Office and the Court of Federal Claims, in size and status process before the Small Business Administration, and in appeals before the Board of Contract Appeals. Sam also counseled clients with claims, requests for equitable adjustments, government contract disputes, and business torts. Anna Sullivan is an associate attorney with Palermo Massa, who assists with supporting the legal needs of businesses that contracts with the government. She works with a group to help government contractors maintain compliance with the myriad of laws and regulations governing federal contractors, including matters involving bid protests, contracts, and agreements, as well as eligibility for small business procurement programs. And with that, I will let Sam and Anna take it from here.
Thanks so much, Ed, and I really appreciate the introduction there. I'm going to kick things off for everyone today. So let's start on the presentation here for those of you that are participating and can see the slides. Here's a little more about Anna and myself. Our contact information is on the slide presentation as well for anybody that has questions afterwards or wants to follow up on any other unrelated issues as well. I'll tell you just a little bit more about the firm, Palermo Massa. We are a business law firm. We specialize in representing primarily government contractors, and within that general, pretty broad industry, we represent a lot of small businesses and companies that have distinctions and participate in SBA's different socioeconomic programs. Within that world, we, as Edna mentioned, we handle a lot of claims and disputes, bid protests, size, status protests. A lot of our practice revolves around just general counseling for compliance under the federal acquisition regulation and a lot of the nuances of SBAs regulations as well. But we also, sort of become, since a lot of our clients are on the smaller side and maybe don't have their own in-house counsel yet, we sort of become the general outside counsel to a lot of our clients, advising them on broader issues, not just related to government contracts. That has allowed us to develop a large litigation group. We have a business and transactions group, and we have a labor and employment group as well. So we really become, for a lot of our clients, sort of one-stop shopping for general legal needs, even those that don't necessarily touch specifically on government contracting. So this is the overview of the topics we're going to touch on today. We've got a lot of information to get through. As Edna mentioned, we will try to answer questions throughout the presentation, but we're also going to try to reserve some time at the end to answer any questions that we aren't able to get through as we're going through the slides here. The different topics, we're going to start by just talking about what past performance is, the general rules governing how past performance gets evaluated, and when agencies do and do not have to consider past performance in as an evaluation factor in different competitions. We're also going to talk about the different types of past performance information that prime contract offerors can rely upon when submitting bids. And then we're going to get into some of the best practices for making sure that you have good past performance and that you can promote good past performance evaluations on projects that you're working on. And lastly, we're going to talk about how and when you might want to challenge negative evaluations when you receive them from the agency, and sort of the whole process for how the evaluations of past performance are done, and when you can challenge those evaluations, and if you do, what type of relief might be available for you. So the first thing we wanted to talk about at the outset here is, what exactly is past performance? Well, past performance refers to your performance on any active or completed contracts and your orders under, IDIQ or multiple award type contracts that you might have. It's really, as an evaluation tool, it is narrowed down to your performance on contracts of a similar size and scope. And that is because, when past performance is used as an evaluation factor in a competition, the agency is really trying to see, well, what projects have you performed in the past that are similar size and similar scope? Because those are the types of projects that we think are going to be predictors of your capability to perform the current procurement. Generally, agencies are required to consider past performance information when they're making their source selection decisions in negotiated procurements, which is not every type of procurement. That's an important distinction at the outset here. And they also have to utilize past performance information when they're making responsibility determinations, which are required as sort of the final step to an award of a government contract. The reason this topic is obviously super important is because negative past performance can really have severe consequences for a contractor. If you are going through an evaluation and at the end, the government's making that responsibility determination and they find out that you've got really bad records out there related to your past performance, maybe you've been terminated for default in the past. Those are the types of things that could lead to you being denied award on the basis that you're not responsible. If you're currently performing a contract and your performance isn't great, well, that can certainly lead to you being terminated for default, which can then have those consequences of impacting your ability to go after future work. So really an important topic today that we're going to talk about. So I was sort of mixing the terms there with past performance and responsibility. So we do just want to note the distinction here between the two. Responsibility is, unlike past performance as an evaluation factor, it is a yes-no assessment as to whether the contractor at issue has the requisite resources, business integrity to perform the contract. So it's really a determination that's made at the end. For a lot of small businesses, this can be a sticking point, because if you're a small business and you're going after a set-aside contract, if you're deemed to be non-responsible by the contracting officer, that's a determination that then has to get kicked over to the Small Business Administration to go through their certificate of competency program to weigh in on whether you are in fact not responsible to perform. So as I noted, some things that could lead to non-responsibility findings would certainly be being terminated for default based on your performance on prior contracts. There's a host of other things that could lead to a non-responsibility determination, which aren't necessarily germane to our topic today. Certainly, if you don't have financial resources, don't have a history of good business integrity, those sort of things. And then distinct from responsibility is a past performance evaluation, which is really just going to be one of several comparative evaluation factors used when the agency is determining who the best value contractor is under FAR 15, which are negotiated type procurements. It's not a factor when we're dealing with a sealed bid situation under FAR Part 14, because in those instances, the award is going to be going to the lowest priced, responsive, and responsible bidder. So some of the general rules here for a past performance evaluation. In negotiated procurements, like I mentioned, FAR 15, the general rule in the FAR is that the agency should consider past performance information from predecessor companies, key personnel who have relevant experience, or subcontractors that are going to perform, and the important thing here is only subcontractors that are going to perform major or critical aspects of the work, and their information is relevant to the instant acquisition. So that's what FAR 15 at least says about what type of past performance information agencies should consider when conducting their evaluations. There are some nuances to this that we're going to get into, how these rules have evolved as it relates to SBA's regulations and case law from GAO. But the thing to I guess the big takeaway at the outset here is that should is obviously not must. So just when generally thinking about past performance, there's a lot of discretion in this entire area of the law that's given to agencies, and that sort of bleeds into a lot of the things we're going to discuss today. But it is such a critical component of an evaluation, because often, the difference between it can come, whether or not you win a procurement can come down to just your past performance evaluation, just that part of the overall evaluation. So it's a very important part of the evaluation. It's also a part of the evaluation that agencies have lots of discretion in. So a lot of what we're going to talk about today is how to position yourself to make sure that you're putting forward your best winning proposal from a past performance perspective, and you're trying to walk the line there and understand that the agency is going to have lots of discretion, but how you can do your best to advocate for the best possible past performance evaluation. So a quick note on IDIQ contract ordering, which is under FAR Part 16. This part of the FAR, the rules in FAR 15 do not apply. So the FAR here just says that similarly, agencies should consider past performance on earlier orders when they're awarding, task order contracts under that part of the FAR. And then the other common way that procurements are done is through streamlined acquisition procedures, scheduled procurements under FAR Part 8. And this part of the FAR just says that agencies may consider past performance, which is even more discretionary than the word should. And it really doesn't, this part of the FAR does not explain exactly what type of past performance information agencies may or really have to consider. I'm going to kick things over to my colleague Anna now, who's going to get into a little bit of the different types of past performance you can rely on some of the different rules.
So when can an offeror use subcontractor past performance? By teaming with a qualified subcontractor that might have more experience than you for the type of work you're going after, you might be able to use the past performance references of the subcontractor that could ultimately help you win the award. So it's important to know when you can and cannot rely on subcontractor past performance. And this depends on the type of procurement and the terms of the solicitation. For FAR Part 15 procurements, an agency may consider subcontractor past performance information where the subcontractor will perform a substantial portion of the contract, so essentially a major subcontractor. And for FAR Part 8 procurements, aka Federal Supply Schedule procurements, there are no defined rules. But this Atlantic Systems case here appears to establish two separate default rules when the solicitation is silent on the issue of subcontractor past performance. So for FAR Part 15, the agency must consider past performance references submitted for proposed subcontractors, at least for major subs or subs that will perform critical aspects of the requirement. And for FAR Part 8, the agency has discretion to disregard subcontractor references. So offerors should not assume that a sub's past performance will be considered unless it is explicitly stated in the solicitation that the agency will consider subcontractor past performance. Okay, so there was a new SBA rule that became effective in November 2020 that requires agencies to consider the capabilities, experience, and past performance of first-tier subcontractors where the first-tier subs are specifically identified in the proposal and the capabilities and past performance of the
I think we lost you there for an Anna. Are you still there? Okay, well, I'll jump in.
Then required to consider it. Sorry, Sam, were you saying something?
Yeah, I think we lost you there for a second, or at least I lost you for a second.
Okay, can you hear me now?
I can, yep.
Okay, great. So I'm not exactly sure where I dropped off, but yeah, if you're a small business offeror and you don't have the capabilities to past performance necessary for award, you can use the sub's past performance and the agency is then required to consider it. Okay, so as for some key takeaways, you will want to seek clarification if the solicitation is not clear regarding subcontractor past performance. So you'll definitely want to be proactive here and look through the terms of the solicitation, perhaps confer with counsel, and if you cannot figure out by the terms of the solicitation if subcontractor past performance will be considered, you might want to seek clarification with the agency during the proposal period. You may even want to consider a protest if the agency is not amenable to considering subcontractor past performance. So if you plan to use subcontractor past performance, your proposal should articulate the name of the sub or teaming partner and what major work or critical aspects of the project the subcontractor will be doing. Some solicitations give subcontractor past performance weight relative to their proposed scope of work. So if this is the case, you'll want to make sure that you break down the percentage of work in your proposal and assign discrete tasks to the subcontractor if possible. And as I mentioned before, small business offerors can rely on first-tier subcontractor past performance in certain situations, so you want to keep that in mind as well.
Yeah, I think the other key takeaway here is just that it's such a discretionary area for agencies, and obviously, a lot of times people are putting together teaming arrangements and having subcontractors for the express reason that they themselves don't have the qualifications to perform the prime contract on their own. So they're putting these teams together so that they can have a winning team that, through the different experiences of all team members, satisfies the requirements of the procurement, and they're obviously planning to dish out those certain parts of the procurement to their subcontractors that those subcontractors have great experience performing. So there are a lot of reasons why these rules have come into play, and why there's a strong basis to rely on subcontractor past performance, and why the rules have sort of started to shift that way. But keep in mind, there might be procurements where the agency isn't clear on it, or might even say that you can't rely on subcontractor past performance. If that's the case and you see that and you're trying to put a team together and use their references, you really want to consider advocating with the agency, and, like Anna mentioned, potentially protesting. The agency might be able, in certain instances, to limit subcontractor past performance references, or altogether exclude it if we're not talking about set aside contracts here or small business prime offerors. But they've really got to establish a reason why it makes sense for them to discount or not consider altogether subcontractor past performance.
All right, so as for key personnel past performance, for FAR 15 procurements, the evaluation should take into account past performance information regarding key personnel who have relevant experience. So GAO has held that solicitations that expressly prohibit an agency from considering key personnel past performance does not violate the FAR. So this is in line with the fact that the agency, has a lot of discretion here. But GAO has also held that where the solicitation provides for consideration of past performance of an offeror's management team, the agency was required to consider past performance of the offeror's managers. So a lot of times the solicitation will control. So it's very important to review these terms at the outset. And as I mentioned in the last slide, you might want to consider seeking clarification if the solicitation is not clear on the key personnel past performance.
So I'm going to handle the next couple topics here. The next one we're jumping into is the rules related to when an offeror can rely on affiliate past performance information. So this comes up often with companies that have subsidiaries. They have different divisions within the larger company that they have hived off and are actually organized as individual LLCs, or companies that the rules of affiliation are well defined under SBA's regulations. And there's we could do a whole presentation on affiliation in general, but there's what an affiliate is really a company that you have the power to control, or that has the power to control you. So sometimes when you're putting a proposal together, you might want to rely on past performance of one of your affiliated companies. So the rule here is GAO has held that an agency can certainly consider that, so long as it's not expressly forbidden by the solicitation, and the offeror's proposal represents the affiliate's resources. And so what that really means is it's explained in the proposal the workforce, the management, maybe the facilities, or the other types of resources that your affiliate will be providing, or that's going to be relied upon for contract performance. And this is the key thing here, such that the affiliate will have a meaningful involvement in contract performance. So we get a lot of clients that come to us that just say, hey, we've got 4 sister companies in our larger organizational structure. One of our sister companies that's not going after this specific contract we're talking about, has done this type of stuff before, or has a great past performance reference for this type of work. Can we rely on that? And the answer is maybe. And it's a tougher hurdle. You've got to get over the threshold here of what the language I just read says. So what you've got to do is you really got to make sure that there's something about that affiliate reference that is going to be indicative of your performance on the contract you're going after. So certainly if that affiliate reference was performed by, employees and individuals that are not going to be working on the current contract, well, that's not a helpful fact. If the affiliate's not going to be at all assisting you by providing, managerial staff or some sort of other resource, equipment, facilities, and they're just really uninvolved and you're just trying to utilize this great reference they've got, that's not going to work. You really got to do more. You've got to establish that they've got meaningful involvement. And that is really determined on a case-by-case basis. But the cases do say that just identifying the affiliate in your proposal is not enough. You've got to get across that threshold of establishing that they're going to be somehow meaningfully involved in the project you're going after. So you want to consider how you can use your affiliate to support contract performance if they've got this great reference that you want to be able to utilize. You could potentially bring them into the fold as a subcontractor, or you could use them to staff the project, or particularly for key personnel. If they're providing the key personnel, that's a good justification for why their past performance reference should be considered by the agency. Another thing you could do is you could consider submitting a bid with that affiliate where you guys organize a joint venture, and both the affiliates here are members of the joint venture and submit a bid where the joint venture is a prime contractor. And again, with all these, if the solicitation is not clear on this, which a lot of times I will say it's not. Solicitations, the past performance sections and instructions and solicitations can be really vague. They can lead to a lot of questions. Some of these larger procurements where people are really interested in them and they know that it's going to be very competitive and the evaluation could very well come down to past performance. Sometimes this is a hotly contested area. People really want to flesh out exactly what's going to be considered, what's not going to be considered, what points are going to be given to it. And unfortunately, affiliate past performance is not something that's always referenced. It's usually left off the list. It's pretty common for a solicitation to explain, how subcontractor past performance is going to be considered, how performance, if you're submitting as a joint venture, is going to be considered, but affiliate is not usually mentioned. So if you're really trying to rely on affiliate past performance, you might want to press the agency to give you a clarification, submit a question during a Q&A, just take those early steps so that there's the problem here, I think, and what you all need to be aware of is if the solicitation doesn't really say one way or another whether, for example, affiliate past performance is going to be considered. And let's say it says you've got to submit, 3 past performance references, and you submit 2 from an affiliate, and then the agency just disregards them altogether. Chances are, if you file a protest, it's going to be a lot harder after award to establish that the agency should have considered affiliate past performance if the solicitation didn't say they should. So you really want to ideally go into the bidding of the proposal, or sorry, bidding of the competition with a clear understanding of whether you're going to be able to rely on these types of references, which is why having those early conversations with the agency is so important.
There are questions.
Sure, we can answer a question.
Okay, somebody's asking, what if you don't have past performance but have tons of personal performance as a small business?
So do you mean past performance in the sense that, so past performance can really be government contract past performance or any other type of private contract that you performed. And that can be whether you performed it as a prime or as a sub. So I don't know if that answers the question.
Yes, it did, I guess. Another question is, would you repeat the requirements for prime contractors to provide past performance to first-tier subcontractors?
Yeah, absolutely. We can walk back up to that. That's an important rule. So the rules used to be, like we were talking about, there was the FAR rule that said, they should consider major subcontractor. Past performance should isn't a must. There's some case law that sort of fills in the gaps, but effective November 2020, SBA came out with this really important rule that says that agencies have to, not should, not may, but they have to consider the past performance of your first tier subcontractors if those first tier subcontractors are specifically identified in your proposal, and you're a small business prime contract offeror. So if you're a small business, you're submitting a bid, and you can't independently demonstrate the past performance necessary for award. Let's say there's a couple of different, past performance references required. You don't, you're a small business. It's common understanding that you're not going to necessarily be able to satisfy the requirements of a procurement on your own, particularly past performance if you're, a relatively new company. So this says if that's the situation, you're small and you can't demonstrate the performance on your own, well, you can submit past performance references for your subcontractors, as long as they're mentioned as long as those subcontractors are specifically mentioned in your proposal, and the agency has to consider those subcontractor references. So it's really an important rule designed, obviously to help small businesses out so they can compete on a more even playing field.
Okay, the last question is, does 1099 past performance count, or should it be written in a certain way?
If you are an independent contractor for someone, and you've been awarded a subcontract 1099, yeah, I would consider that a situation where you were a subcontractor. But there are some nuances to it, so I'd be happy to chat offline. But as a general rule, if you've been brought on as an independent contractor for a lot of reasons, that's essentially a subcontractor. So you should be able to rely on that type of experience. Is that all the questions, Anna?
There is another one. It's regarding the 1099 audit as well. It says, is it sufficient for past performance if the previous 1099 work is relevant to the RFP?
Yeah, so the important thing to keep in mind is that, I think I'm getting an echo on my end, but the important thing to keep in mind is that the solicitation is going to define what relevant means. So that's really that's your starting point. The solicitation is going to probably say, prime contract offerors have to submit 3 relevant past performance references. And then it's going to have a second section that says relevant for purposes of this procurement means X, Y, Z. And it's often going to say, a contract where, a contract that is similar in scope and size and complexity. So if you're bidding on a contract for IT services that requires you to staff, 35 people, and it's a $10 million contract, you're going to want to, relevant is going to be something similar to that. So similar in contract dollars, similar in the type of requirement. The solicitation might even explain, that for a contract to be relevant, it's got to be between, $5 and $7 million, or at least $5 million, or something like that. So it's really gonna lay the ground rules for what relevant means, which is why it's so important whether or not you can rely on other people's past performance. Because I think what we're getting at here, some of these questions, is you're a small business and you've only got previous 1099 work. Well, that 1099 work might not be relevant because it might not be of the scope that's required under the contract you're going after. In which case, it is going to be important that you're able to understand these rules and utilize them to your advantage. Understand, if I prime this, I might not have any prior experience that's going to help me. So I need to bring in a team here and try and, rely on some past performance of some of my subcontractors. Keep in mind, for procurements that have past performance as an evaluation factor, if you don't have any past performance, that is not a negative against you. It is just going to be viewed as a neutral. So A record of no past performance is equivalent to a neutral rating under this evaluation factor. So it shouldn't lead to a negative rating, but since past performance is so important and can often be the difference between winning and losing a contract, if you get a neutral rating in past performance, it's going to make it hard for you to be the best value offeror, since there's likely to be other contractors that have higher past performance ratings.
I have two more questions if you'd like to answer them or wait later. Okay, the first one. For professional service-based business, would professional experience from an employer counts as an experience? For example, if a key personnel or owner has 20 years of experience as an engineer.
I think I missed part of the question. Can you repeat that again?
For a professional service-based business, would professional experience from an employer count as an experience? For example, if they have 20 years experience as an engineer.
Yeah, so there's a difference between like corporate experience and key personnel requirements. If you've just been employed previously, that's not past performance. Past performance is a contract that your company has performed.
Okay, the last question I have here is, do you have the FAR reference or SBA reference for primes to provide first year sub past performance? I'm not sure what the question is.
Yeah, I think it's 13 CFR 125.2. Yeah, it's right here. 13 CFR 125.2G.
Okay, that's all the questions we have for now.
Great. So let me see, we were wrapping up affiliate past performance. So just a tip here for tribally owned companies. I don't know if there's any tribally owned companies listening in today, but just be careful when you're relying on affiliate past performance information, because tribally owned companies, as you know, they get a broad exclusion from affiliation under 8A procurements. You know, a lot of tribal companies have a lot of sister subsidiaries that all are in, you know, many of them might be in the 8A program, but you as a tribally owned entity can be found affiliated with those entities for other reasons when you're going after small business set-asides. So just be cautious when relying on this past performance information from your, you know, sister subsidiary exempted affiliates, because reliance on that could be a piece of additional information that could lead to a finding of general affiliation if there was a size protest. So just keep that in mind. So the next big category here is when relates to joint ventures, and when a joint venture can use member past performance information. So the FAR, which just is a general rule, the FAR is usually very slow to get updated, and SBA regulations tend to get updated first, and then, you know, when we're talking about these types of areas, SBA's regulations tend to get updated, and then sometimes 5-7 years later, the FAR will eventually get updated. So a lot of times the FAR is not up to date with SBA regulations, like that regulation that requires agencies to consider first tier subcontractor past performance. That just came out in November. I wouldn't expect that to be added to the FAR, although it might, but I wouldn't expect it to be added to the FAR for another few years at least. So in the area of joint venture past performance, the FAR does not have any guidance really on how and when you can use members' performance when they're in a joint venture. That said, a lot of these cases have gone to GAO, and there's a wealth of GAO case law that says that an agency can certainly credit joint ventures with the past performance of their individual members. You know, in this area, the important thing to keep in mind is that joint ventures are often established. Certainly small business joint ventures are often created just for the purpose of going after a specific procurement. So, you know, company A, company B form joint venture, company C on its own as a prime contractor has never performed any work before. So that becomes a big sticking point when that joint venture is now submitting a bid and it's trying to, get a winning evaluation under the past performance factor, and it realizes, well, we, joint venture, don't have any past performance, but obviously we'd like to rely on the past performance references from each of our members. So that's sort of the underpinning of where this all comes from. SBA regulations since 2016 have indicated that agencies should consider the past performance of members to a joint venture, but that led to some nuances and some more questions. So there was an important regulatory change to SBA's rules also this past fall. And now under SBA's rules, they require that agencies consider the past performance from each JV partner, as well as any work done by the JV itself. But what had been happening was, in some instances, the procuring agencies had been saying, okay, fine, we'll consider past performance from each JV partner, but we're also going to require that the joint venture itself submit, for example, one past performance reference. And that led to the whole issue I just mentioned, where a lot of these JVs were saying, well, we don't have one past performance reference because we were just organized. So now the rules say you've got to count the performance of each JV partner, and you can certainly consider and have to consider any work done by the JV itself that it happens to submit, but you can't require rather that the joint venture itself satisfy the past performance requirements. Instead, the joint venture partners in the aggregate under this new rule have to demonstrate the past performance, experience, business systems, and certifications requirements necessary to perform. The other part of the rule indicates that agencies cannot require a protege firm to individually meet the same responsibility and evaluation criteria required of other offerors generally. So that is important because certainly in the mentor-protege context, if you're participating in SBA's mentor-protege program, the whole goal there is to develop and help the protege to grow, and they've got a mentor that's helping them to do that, which sometimes can be a large business, and the natural assumption there is that the protege is usually a fairly new company that is getting into these mentor-protege relationships and getting into these mentor-protege joint ventures so that it can get more experience. So requiring them on their own, the protege on its own, to meet the same responsibility and evaluation criteria of other offerors would be, inherently unfair. An important development here is that SBA, their general authority jurisdiction is related to size issues usually. That's sort of the limit of it, but they have been, they do have a whole host of regulations about how you qualify as a small business when you're a joint venture, how you qualify, as a SDVOSB joint venture. So when they put out these past performance regulations, a lot of people have wondered, okay, well, that's SBA saying how an agency should evaluate an offeror, but we don't know that those rules are going to necessarily be upheld because agencies have their own ability to set the rules for their procurements, and they're, more strictly governed by the FAR when they do that, and the FAR doesn't have all these new rules that SBA has put out. But there was an important case that just came out in April of this past spring, where GAO sustained this new regulation that SBA just came out with in the fall, and they sustained a protest that had challenged a solicitation requirement that required protege members of a mentor-protege joint venture to have the same level of experience as other offerors. The specifics of that case were that the agency had put out a solicitation that required each member of a JV to submit a past performance reference. And there was a mentor-protege joint venture that protested and said, well, this is unfair because we've formed this joint venture because the protege doesn't have its own experience. So we're trying to submit, experience of just a mentor. So requiring one reference from each member is unfairly prejudicial to the protege here and violates this new rule that SBA just came out with. That was sustained. So the takeaway there is that these rules are here to stay, and they can be, relied on if you're trying to make arguments as to why a solicitation should be crafted a certain way. If you see a solicitation that violates this new rule right here, that is something you certainly want to raise with the agency. You might want to file a protest. Now you've got this GAO case that came out in the spring that you can cite to say, hey, you know, the solicitation's got to be recrafted here. You've got to conform with these new regulations. So all of that aside, it's important to remember that agencies can, however, limit the amount of mentor past performance information that can be submitted when evaluating a mentor-protege joint venture. So there was a case in the past that's kind of like the gold standard for this theory of law, where a solicitation allowed 5 past performance references and said that if you're in a mentor-protege joint venture and you're going to be submitting past performance, your mentor can only account for 3 of the 5 total references that the JV is going to submit. It got protested and JAO said, no, that's fine. You have to submit, you have to count the past performance of both offerors, but if you're in a mentor-protege, where the mentor oftentimes is going to be a large business, they can limit how much mentor-protege mentor experience can be considered. The agency can also consider each JV member's relative level of effort as part of its past performance evaluation. So just keep in mind there's thresholds that you got to get across here just to be able to rely on certain past performance, but then the agency gets a lot of discretion in how they actually conduct their evaluation of those references. And when they're conducting their evaluation, they, you know, can consider if you've got a JV and you've got 2 members and they know the relative work share of those members, well, they can use that when evaluating the different past performance references submitted by the different members of the JV. So the other question that comes up often is, when can an offeror that's submitting as a prime contractor use past performance from a JV that it was in? So you've been in this joint venture in the past, the joint venture performed a contract, you got a great past performance evaluation on that contract, you're now going out on your own, bidding a contract as a prime contractor, and you'd like to be able to submit that reference from the joint venture as one of your references that, you know, under your bid that you're going after on your own as a prime contractor. So the rules are a little hazy in this area. It's only clearly permitted when you were the managing member or at least 50% owner of the joint venture. And the rationale there is that, you know, you were the past performance of the joint venture is essentially your past performance because you controlled the joint venture as the managing member, you know, / 50% owner. And in that case, you know, another theory of why you should be able to rely on it is because it's sort of analogous to affiliate past performance. You know, that joint venture is essentially one of your affiliates. You controlled it, so it's your affiliate. So you should be able to rely on that type of past performance when you're bidding on your own. OHA has announced that, sorry, this should not say OHA, this is actually GAO. So GAO has announced that when an offeror relies on past performance of a firm as a participant in a joint venture, the agency can consider the past performance on the basis that the offeror had a sufficient role in the joint venture to make the performance relevant. So it's unclear what sufficient role means, but certainly if you were the managing member and, you know, you had a 50, 51 or greater % stake in the company and performed, you know, an equal amount of work in that joint venture, well, that's probably going to qualify as sufficient. If you're a minority member and you perform 20% of the work, well, that might not qualify as sufficient. So you might not be able to rely on that joint venture reference. And the last note here is just that when doing this analysis, GAO has compared it to that of the affiliate analysis I outlined earlier, which just talks about, you know, meaningful involvement. Essentially, is what you've got to establish. You've got to establish that they should rely on that JV past performance reference because you had meaningful involvement in the JV's performance of the contract you're trying to use. So I'm going to kick things back over to Anna now, who's going to talk a little bit about CTAs.
Okay, so as for contractor teaming arrangements under a GSA schedule, a CTA essentially is a written agreement between 2 or more scheduled contractors to work together to meet an agency's requirements. But unlike a traditional prime sub relationship, each CTA member is responsible for its duties and has privity of contract with the government and must have a GSA schedule contract. So here, since each member has privity of contract, an argument can be made that all CTA offerors shall be able to rely on the past performance of all CTA members. But if reliance on a CTA member is unclear, an offeror should, again, consider seeking clarification or protest the solicitation as unduly restrictive. So the more proactive you can be here, the better. All right, so when can an offeror use acquired past performance? So Part 15 says an agency should rely on the past performance information of a predecessor company. A predecessor company is an entity that is replaced by a successor. And a successor is an entity that replaced the predecessor by acquiring assets and carrying out the affairs of the predecessor under a new name, which is often done through a merger or an acquisition. Note that this does not include, getting a new office, a division of the same company, or a company name change. All right, so this routinely comes up with the novation process. So this is when you acquire another company, but transferring contracts is precluded under the Anti-Assignment Act. So an exception to this is novation, and this is where the government can transfer contracts from one party to another by recognizing the acquiring company as a successor in interest. So when contracts are novated, they are assigned the cage code of the successor entity. So as such, after the novation is complete, the predecessor's contracts should all show up in the CPAR system under the successor's cage code. But however, novation alone does not require an agency to attribute this past performance of a predecessor company to the successor company. So the key consideration here is whether the experience evaluated reasonably can be considered predictive of the offeror's performance under the contemplated contract. And GAO has upheld an agency's past performance evaluation that relied on novated contracts where the successor in interest under the novation agreement is essentially the same entity.
Yeah, another important consideration here, and certainly as companies grow and they become ripe for an acquisition, maybe your company specializes in a certain type of service that's really unique. You develop a great record of past performance. You build up your company to be really efficient and have great evaluations from agencies. You've got a bunch of great contracts you've worked on. Another company approaches you and says, hey, we want to buy your company. We're going to novate the contracts. We're going to continue performance under your contracts. And then the great thing is we're going to get all of your past performance. We have a lot of clients that come to us to say, well, hey, I'm buying this company, so I get to now rely on their past performance, right? As Anna was talking about here, that's not a de facto rule. There's a lot of nuance to it. The agency, again, has a lot of discretion here. Oftentimes you're going to have to, show, as she just highlighted, that past performance, there's a reason that the past performance of some company you have nothing to do with should now be attributed to you going forward, particularly if it's closed out contracts. I mean, if you acquire a company and they've got a bunch of open contracts, those contracts get novated to you, and you, as the acquiring company, now continue the performance of those contracts. Well, now you've actually performed them with your own people. So in that case, it would make sense that you should be able to then rely on that type of past performance when you're going after future work. But if you acquire a company and you just get all their records and all the paperwork related to a bunch of contracts they've performed, it doesn't, necessarily follow that those contracts this company already performed have any bearing on how you might perform contracts in the future, which is the whole basis of a past performance evaluation, is just try and understand your prior performance so the agency can get a good sense of how you're going to perform the contract you're going after here. So what are some of the best uses of past performance information? Some of the things you can do to really be proactive in this area, as we've talked about here, are to try and shape the RFP requirements to fit your needs. Depending on your goals in the past performance area specifically for today's discussion. If you see a procurement that hits the street, you think, okay, great, we can satisfy and knock it out of the park under the past performance factor if we are able to rely on one of our subcontractors. We've got this joint venture that we were in before. We want to rely on that reference. Maybe we've got an affiliate. Sort of think through your perfect world for how you'd get a great evaluation, and then try and reverse engineer how you might be able to make sure that you're going to get credit for all those things you're trying to submit. So this can be, you really want to try to work with the agency where possible to ask questions. You can submit letters. We've certainly done that in the past for clients where they're trying to get a certain outcome. They want the past performance factor to be drafted a certain way. They want consideration of joint venture references, consideration of certain subcontractor references, affiliate references. So there's a number of ways to sort of advocate for that if the solicitation doesn't have the terms that you're looking for. Those things you might not necessarily, there's no guarantee that you're going to be successful in those efforts. But if you've got, so if you've got a reason then to think that the terms and the restrictions in the solicitation are unduly restrictive, the agency's, putting some preclusion in there on considering past performance of subcontractors, and you think they've got no basis for it, or it violates any of the regulations we've discussed today, you're not able to convince the agency to back off its approach prior to submitting a proposal, well, then you might want to submit a protest challenging the terms of the solicitation, which could lead the agency certainly to take corrective action and revise the solicitation to have the terms that you're looking for. You want to make sure that you're providing to the agency when you're going after these awards past performance references that are tailored to the RFP's evaluation factors. So, look through how the RFP defines what is relevant, and make sure that you understand what the contract's requirements are so that you can submit references that show, hey, we've done this exact type of work before, or we're working with this great company and they've done this exact type of work before. And here they're going to be our subcontract performing, this discrete portion of the work where, that they've previously done in the past and they've got great scores for. Another thing you want to do to sort of stay on top of things is you want to monitor the sources of information that are out there that have your past performance information. So, certainly talking to agencies to see what they've heard about your past performance, just to sort of understand your reputation within the industry. But the other database that you all should be familiar with is CPARS, which is where if you're not familiar with it, we're going to talk about it a little bit more. So I'll probably answer a lot of your questions then, but that is the Contractor Performance Assessment Reporting System. That's where the agency actually stores the evaluations that it does on your performance of contracts. So there's a whole host of requirements for when the agency has to perform CPARS. They have to do it for certain contracts that are over certain thresholds. And these evaluations are done, if it's long-term contracts, they're done, every year. Otherwise, they're done at the end of performance, and there's a whole back and forth process. But ultimately, there's a record at the end of the day that's got this evaluation from the agency that explains how you performed under a contract, and there's ratings, and those are usually the references. And we've been talking today about all these references you're going to submit. Oftentimes, you're submitting a contract as a reference, and you might even have to submit the CPAR itself, or a past performance questionnaire that's going to be completed by the contracting officer that was on this contract you're talking about. Another database here is FAPIS, which I forget exactly what that stands for, Federal Acquisition Procurement Information System. That's essentially the database that you can search, publicly available database, but that's going to have records on any sort of significant events that occurred during your contract, such as a non-responsibility determination, or as it relates here today, terminations for default or terminations for cause are going to be in that database. PIPERS, this last database, is just a database that integrates with CPARS, so it's sort of one and the same there. But FAPIS is a good database to keep in mind, because CPARS, you can access as a contractor your own CPARS, but you can't access other contractors' CPARS. Agency can access anybody's, but you are only allowed to look at yours. But FAPIS anybody can search that. So just a word of the wise here, if you're doing matchmaking and you're thinking of working with certain companies, do some due diligence on them. And one of the things you can do is certainly check FAPIS, see if they've ever been terminated for default, because you don't want to tie yourself to a subcontractor and then find out, after the fact that they've got this horrible mark on their record that's going to impact the way that you get evaluated. Another thing you can do is participate in debriefings. So if you don't get an award, a lot of times you can ask for a debriefing. Sometimes under the FAR, debriefings are required for certain procurements. They're not required for all procurements, but you can always ask for them. Sometimes agencies give them anyways. And the thing that you can ask for in a debriefing is information about how your past performance was evaluated. And they may share that information with you. They may withhold a lot of it, but either way, it's a good way to sort of stay on top of how you're being evaluated and certain things that agencies are dinging you for during these evaluations, because depending on what the debriefing says, that might lead you to want to file a protest saying, well, hey, there's no way that you should have evaluated me that way under the past performance factor, for example, because we know that our past performance, we have all this great past performance that we submitted. So if you know more about why you were negatively evaluated, you might be able to use that as a basis to protest the agency's evaluation decision overall. And as I just indicated there, examine subcontractor and teammate past performance information to the extent you can get it. FAPIS is one place to check for those records. Unfortunately, you can't get their CPARs unless you ask them for them and they provide them, which they may not want to do, but it's certainly worth asking if you're really trying to do your due diligence. Of course, Googling, doing your own sleuthing online is another great way to get information about companies you might be working with. And you can ask, other people in the industry, people that have worked with them in the past, their own references to try and get a better understanding of, what skeletons might be out there that could come back to haunt you when the agency does its evaluation and digs up a bunch of dirt about one of your subcontractors. So optimizing your performance is another important thing to keep in mind. So really this is, sort of trying to be proactive as you're performing a contract, because every contract you have, you're then building your, rapport and your record with the agency that's going to ultimately lead to a performance evaluation at the end of the contract. So the best thing you can do to make sure you have good past performance is make sure you're doing your job and you're doing everything to make sure that you're on track for a good evaluation at the end of the day, so that this great contract you've been awarded after you've performed it turns into a great reference for you to go after other work and get additional awards down the road. So make sure that you're vetting your quality assurance plans, you're meeting your performance schedules. Keep track. This is another important thing that I tell a lot of clients is keep track of any kudos that you get from agencies. If they send you emails, praising you for your good work, it might not seem like anything at the time, but as we talk about CPAR evaluations a little bit further on here, that stuff can be really helpful when you're trying to, justify down the road that you should have gotten a better evaluation or something. If you've got this great record of the agency saying, awesome job today, keep up the good work, we're so happy with what you guys are doing on site, document that stuff. And certainly if any issues come up, make sure that you're trying to remedy those as soon as they arise. Continuously assess whether you're on track to meet the different milestones in the contract. And you also want to make sure that you know the different justifications for evaluations, which we'll talk about in a minute here. And you want to make sure that you certainly timely perform. But another great thing to sort of optimize your performance at the outset, and we'll talk about the definitions of CPAR's evaluations in a moment here, but one of the things you can do is when you're having that kickoff meeting, or you're getting on site and you're starting to talk with the agency representatives, say, hey, we know the contract requires X, Y, Z. We're obviously planning to meet all those requirements. What could we do, or what are the types of things that we could do that you would think are additional benefits to the agency? And if you get a clear understanding of what things they would really value that would go above and beyond the requirements, well, then to the extent you can do it, you can try to do those things. And then you've got a clear understanding of the rubric. And then if you do those things that the agency's already flagged as being really important to them. Well, at the end of the day, when they go to give you an evaluation and if you aren't pleased with it, you can say, well, hey, not only did we meet the contract requirements, but you told us all these additional things that we could do that would make you even happier, and we did all those things. So we don't deserve just a satisfactory CPAR evaluation. We deserve to get, outstanding ratings across the board. So the next big topic we're going to talk about here is defending your past performance. So agencies, when they're doing their past performance evaluation, they have to consider the reports that you have in CPARs. The FAR requires agencies to monitor compliance with past performance evaluation requirements and to enter past performance information into the CPAR system. So the CPAR system is tied to those other databases I mentioned earlier, FAPIS and PIPERS as well. But CPARs is usually the primary resource relied upon by agency officials when they're conducting their evaluations. And this is just sort of the rubric for what the FAR says these evaluations are supposed to look like. A CPAR evaluation is supposed to include a clear, non-technical description of the contract and clear, relevant information that accurately depicts the contractor's performance. And it has to be based on objective facts supported by performance data. The agency can use certain prescribed evaluation factors. The most common ones are quality, management, schedule, cost control, and if small business subcontracting is important, that could be included in there as well. But those are really the factors that they evaluate you under, and they're supposed to perform an evaluation under each of those factors that's based on clear information and objective facts and is supported by data, which is why I mentioned a moment ago, it's so important to track the data that you're developing and your performance on site contemporaneously, so that if there's any difference of opinion, you've got a good basis to challenge these types of evaluations. So the different types of CPARs evaluations there can be, there's interim evaluations. These would be annual evaluations. All annual evaluations except for evaluations completed at the end of the contract order. So if you've got a long-term contract or just a contract, for example, that's over a year, the agency has to do an interim evaluation of the first 180 days. But it could include, most often, it's going to include the first year. And then they've got to do an evaluation every 12 months. So if you've got a 5-year contract, chances are, and of course, the agency doesn't always follow these regulations clearly. That's a whole other topic. But if they're doing what they're supposed to do, if you've got a 5-year contract, you should get 5 CPARs. You'll have an interim CPAR for every year of performance, and then you'll have the final evaluation, which is completed when the contract ends. And that's done, after any options that have been exercised. The important thing to keep in mind is that each of these evaluations really should be done in a vacuum. So, you're in year 2 of the contract. You've already gotten an evaluation for year 1. The year 2 evaluation shouldn't consider anything that happened during year 1. It should be limited to your performance during year 2. The same is true for year 3, year 4, and when you get the final evaluation. The final evaluation's not a catch-all summary of your performance under the previous 5 years. It's the evaluation of that last year, which is important because if you've got, let's say things didn't get off to a great start year 1, you didn't get the best ratings, but then gradually you picked up your ratings, and by year 5, you've got all outstanding ratings. Well, it's important to see that trend, and that, is something agencies should consider when they're looking at the CPARs for that contract. They should say, well, yeah, maybe these guys didn't have their ducks in a row day 1, but it looks like over the course of the project, they really, knocked it out of the park and did a great job performing. Past performance information is valid for 3 years, or if we're talking about construction or architect engineering contracts, it's for 6 years, and that's from when the contract is completed rather. So if you've got a 5-year contract, that your evaluations under that whole period of performance are going to be utilized, or at least can be utilized by agencies for 3 years. The good thing to keep in mind here is that if you've got bad performance, at a certain point it becomes stale, and an agency can no longer use it against you. So once a contract's been performed for the 3 or 6 year threshold, it's you can brush it under under the rug, and you don't have to worry about it anymore. So these are the definitions that I alluded to. Familiarize yourself with this table, which is in the FAR. The reference is here at the top of the slide. These are the different types of ratings you can get for a CPAR. Satisfactory just means that that's unfortunately, there's a big trend right now with CPARs sort of going towards satisfactory. That just means that you met all the requirements of the contract. There might have been some minor problems, but you took corrective actions that satisfactorily resolved any of those problems. It sort of stays within that same rubric for all the different ratings. Exceptional would be the best. That means that to get exceptional, you have to actually exceed the contract requirements. That's why I said if you're trying to shoot for these higher ratings, you might want to ask the agency what would exceed their expectations at the outset. That way you know the ground rules and you can try to do that. Marginal, unsatisfactory, those are the ratings you don't want. And really, you want to, if you can, get better than satisfactory, because if everyone has satisfactory, the one offeror that's got anything above satisfactory is probably going to win the day when it comes to past performance evaluation. So Anna's going to now talk a little bit about responding to negative CPARs.
All right, so if you get a notification in the system that you've received a past performance evaluation, like what are the next steps? Well, the first thing you'll want to do is, circulate the evaluation to your team members and everyone that was working on the contract, and have them do a run through to flag anything that they disagree with. If there's any outliers, any information that, isn't relevant or related to the contract at issue. And then you'll want to calendar and flag your response date, which is going to be 14 days after you receive the notification. After the 14 days run, the CPAR is automatically published in the system together with any comments that you submitted. It will then be accessible for review for any other procuring agency. And the CPAR's guidance technically does permit you to submit comments for up to 60 days after this notification. But if you submit them after the 14-day window, they're not going to trigger a formal review necessarily. So you want to make sure that you get these comments in a timely fashion. Okay, so how do you respond? What should you say and not say in a rebuttal? So you don't want to put in any information in here that's going to, cast you in a negative light. You want your response to be professional, and that will paint you in a positive light. And as for drafting the rebuttal itself, you'll want to address both procedural and substantive deficiencies in the evaluation. So if there's any failure to follow the requirements of the FAR, any mistakes in the facts that are supporting the evaluation, and include within this any copies of supporting information, including records, any notes, emails from the agency, any other documentation that you have that might contradict the conclusions that were drawn by the agency. So you can do this on your own, but we have a lot of experience with this, so it might be something that you'll want the assistance of counsel on to help draft your rebuttal to ensure that you're flagging all of the issues that you might not be thinking about. And if you have any pending proposals out there, you may want to consider asking the procuring agency not to rely on any negative past performance evaluations, at least until the reviewing official has issued a final decision on your CPAR. The agency can still rely on this information, but they might be persuaded that reliance on this CPAR information might be unfair or prejudicial. And as for avoiding publication, the government is not required to wait to publish, but they might be persuaded again not to. So you could try to set up a meeting with the evaluation team of the agency, or maybe even contact government counsel to try to initiate some negotiations. But note that the courts and the boards have found that a CPAR's challenge is a matter under the Contract Disputes Act, so injunctive relief is rarely, if ever, granted when it comes to publication.
Yeah, and I will just say you can't technically attach documents when you're drafting your rebuttal that you're inserting into the CPAR system. So a lot of times when we work with clients, what we help them do is draft that rebuttal that they're going to just cut and paste and upload into CPARs, and at the same time draft a much more beefed up legal letter that sort of outlines reasons for why the CPAR should be changed. And that's where you can really hit the agency with all these exhibits and attachments if you've been doing your job and documenting kudos and sort of staying ahead of things so that you can try to, explain with support exactly why your rating should be higher.
Okay, so any disagreement with the CPAR's evaluation must be reviewed by a reviewing official above the contracting officer. And then this reviewing official must issue a written decision, which then becomes part of the final evaluation available on the CPAR system. This entire process is supposed to happen within 20 days after the end of the contract's period of performance. And it's important to keep in mind that the ultimate conclusion on performance evaluation is a decision of the contracting agency. So even though you have a right to rebuttal and then this can be reviewed, it still comes down to the agency. And like Sam kind of mentioned on the last slide, our usual strategy is to help our clients put together a rebuttal response in the CPAR system, and then additionally help with an actual letter that goes into the to the contracting officer that has more legal arguments and attaches all of the exhibits with supporting information. So something to keep in mind. Okay, and can you appeal the final CPAR? So once you get the final CPAR, if you're still not happy, there's really no formal appeal process in the FAR. So you'll have to look to the Contract Disputes Act and the disputes clause of your contract. And the CDA permits you to appeal to the board or the Court of Federal Claims, the final decision of the contracting officer. But in order to appeal this, you have to establish standing. And the comments that you submit during the evaluation process are not necessarily a claim for the CDA purposes that will give you standing. So you'll want to ensure that you submit a separate claim challenging the decision that is seeking a final decision under the relevant disputes clause. And once the contracting officer makes a decision on this, then you will have standing that you can then appeal. Okay, and then as far as timing and venue for a claim, claims must be filed with the contracting officer within 6 years. But you will not want to wait the full 6 years. You will want to do this quicker than that. And if the contracting officer fails to respond within the required time period, you can deem this a denial and appeal. If your claim is denied, you can then appeal to the board or the Court of Federal Claims, and you have 90 days to appeal to the board and 12 months to appeal to the Court of Federal Claims. But once you choose a venue, you cannot switch between the two. And we generally recommend going to the board just because it'll be, typically quicker, more cost effective, and you'll probably get the best chance of getting an early resolution and getting the agency to take action on a negative CPAR.
So a little bit about the process for CPARs, claims, and appeals here, and some of the relief. So, and the arguments you're sort of making when you're filing a CPAR claim is that the agency misinterpreted or failed to follow the performance evaluation provisions. So there's, the FAR says exactly how they're supposed to do a CPAR evaluation. There's a manual out there that also has some more color on how they're supposed to do that. So a lot of times, when we're doing this, we're arguing that they didn't follow what they were supposed to follow when they were doing the evaluation. They breached their duties by doing an incorrect evaluation, or these are sort of the legal terms, but their evaluation was arbitrary, capricious, abused their discretion. Those are sort of the backbone of the legal argument that you make. The pleading standard that you've got to satisfy is that you've got to plead facts that give rise to a plausible inference that the government abused its discretion in awarding the negative performance rating. So I will say, taking this all the way to the mat on an appeal, it's a difficult burden to carry, but it still doesn't mean that it's not worth doing it. We've been involved in a lot of cases where we've helped with the rebuttal, and maybe that initial step didn't work, but once we filed a claim, the agency, threw in the towel and didn't want to fight it anymore, and became, cooler heads prevailed, and they were more reasonable and led to, a change in the CPAR evaluation. So the relief that you might get if you were to file a claim and then that claim gets denied, and then you have to appeal it to either the board or the court, it's really a declaratory judgment that you get. The boards and court don't have the ability to direct the agency specifically what to do, but they would essentially issue an order interpreting the contract clauses, the parties' rights, and they would decide whether the agency breached its duties when they were conducting the evaluation. So, perfect case, you have, obviously you hope you never have to get here, but if you do have a claim and then you have an appeal and the appeal goes in your favor, you get this order, an opinion from the board or the court that says, yeah, the agency abused its discretion in performing this evaluation. You would hope that would then lead the agency to pull a CFAR down from the system. Again, they wouldn't have to theoretically, because the court and board can't direct them what to do. I would like to think they probably would if there was, a court calling them out on this and saying, you guys got this wrong. But if they didn't and the CFAR still lingered in the system, you could then use that declaratory judgment, and essentially anytime you're explaining this negative CFAR that's lurking out there in CFARs, you could, say, hey, procuring agency, look, there may be this negative CFAR floating out there, but here's an order from a court or a board that says that CFAR is not warranted, says it's irrational. And then if an agency relies on it anyways, you could use that potentially to set the stage for injunctive relief in a bid protest. But those are hopefully steps you never have to get to in this process. The Court of Federal Claims also has the authority to remand the matter back to the agency. So that means, if they find that the evaluation is unreasonable, they could say, okay, they could say, okay, agency, this evaluation is unreasonable. You got to go back and redo it. Also, just keep in mind the reason that you want to avoid this whole escalated process, although it's very important to challenge and rebut CFARs when you think they're unwarranted. The goal is to avoid a drawn-out litigation, because you're really arguing over something that's not monetary. You're not going to get money at the end of the day. You're not going to get your attorney's fees paid. So you're really, you're throwing a lot of money into a fight where at the end of the day, if you win, it's just going to be a piece of paper that says this evaluation was unreasonable. You're not going to be able to recover financially. So it can get pretty costly getting involved in these cases. So that's just something to be aware of. But there was a case recently that said you may be able to recover monetary damages, which are, for example, the types of damages that you would incur when addressing the unfavorable review on future proposals, and in the form of negotiations as well as protests. So to the extent you prevail and that negative CFAR lingers out there, you might be able to, recoup those costs. But really, the goal here would be to settle this type of thing early on. So CFARs, claims, appeals, the big takeaway here, is it worth it? As I just indicated, like a lot of these cases do settle or are dismissed before a hearing. It makes sense because, like I said, you're not going to get monetary damages here. There's little incentive to litigate this. The agency, most of the time, unless they think they are just so justified in their negative evaluation, and you guys are at total opposite ends of the spectrum, and they think there's no way that at the end of the day you're going to be able to establish that the evaluation was unreasonable. They don't want to litigate these in court. They've got a whole host of other things to do. They don't want to be enthralled in these types of cases that drag on for months or years. So to that end, there's only ever been one published board decision that actually went all the way to a hearing and went to a final opinion that specifically related to whether a CFAR was fair or reasonable. In that case, the agency, or the board rather, ultimately ruled that the CFAR was fair due to the contractor's non-compliance with a bunch of requirements and its poor performance. So, seems like, oh man, even if we fight, we're never going to win. The implications of this case are actually a little bit different, at least in my opinion, because although this case wasn't necessarily successful, it confirms that the board certainly have the authority to review CFARs, can get into the weeds here, and can look over an agency's shoulder. And while this case might not have been, the poster child for winning a CFAR's appeal, it indicates that the board certainly could rule that a CFAR is unfair. And agencies don't want, they don't want a board or a court second guessing them, looking over their shoulder, calling them to task if they find out that, if they rule that the evaluation was unfair. So the fact that there's been a published decision does mean that you can, if you've got a good argument, you can tell the agency, hey, we're serious about this. We're going to fight this. If we're talking on your behalf, we'll say, hey, our client's not happy here. This this is something they take seriously, and they're willing to go to the mat on this. So the big takeaways for CPARs: just make sure that you're carefully staying on top of those deadlines. When you get a CPAR evaluation, when you get that email notification from the system, make sure, like Anna said, you're circulating it with your team, you're identifying potential issues, consulting with counsel if you think it's necessary. We do it a lot, pretty cost effectively on the front end, but it can really help sometimes to get an attorney involved, because then if there's already some animus to the agency, a lot of times we can get an agency attorney involved, and then third parties are really dealing with it, and they're looking at it more critically and sort of taking the passion out of the room. Make sure you engage the agency early on to understand the issues, understand who's going to be performing the evaluation, and if it's appropriate, make sure that you carefully vet the CPAR and you flag those concerns that you have, and you submit that rebuttal within that 14-day period. And if circumstances warrant it, you submit a more significant letter with documentation challenging the evaluation. And if things go further, you could certainly appeal it or file a claim. And while that rebuttal is being reviewed, if you've got other procurements out there that you're getting evaluated on, make sure you try and reach out and see if those agencies will, consider not looking at the evaluation until it goes final, or at least until you get your rebuttal into the system. If after you get this final decision, you think that the agency still got it wrong, certainly you can consider a claim. And if at the end of the day the claim is unsuccessful, you can consider an appeal. So that is everything we have for you guys today. I know we cruised through the second half of that. There's a lot of material that we covered. So I think we're just about at time, but Anna and I can stick around for a few minutes here to answer any questions you guys have left.
I have somebody who has his hand raised, so I guess they have a question. I will try to unmute you so you can unmute yourself and you can ask the question. Marvin Jackson, do you have a question?
Yes, ma'am. Just one more time on the prime contractors giving first tier subs past performance. If you can repeat the SBA rule or the CFAR numbers one more time, I would appreciate it.
It's 13 CFR 125.2G. The rule says that if you're a small business offeror and you can't satisfy the past performance requirements on your own, the agency has to consider the past performance references of any first-tier subcontractors that you are working with, provided they are identified in your proposal.
And that's 13 CFR, real slow. I got a prime that doesn't want to give me past performance.
125.2, and it's section G.
Thank you.
Yeah, absolutely.
Okay, I have.
Any other questions, Edna?
Yes, Gary Gray, unmute yourself, please, so you can ask your question. Go ahead.
So we have a JV with 4 members, and I know you talked about JV past performance, and in some cases it's just one member of the JV leading it, and in others we have 2, and in some cases obviously there's none. Can we use that past performance if we perform substantially as a JV member? And it's, I know you said 50%, but in some cases we don't even, the JV doesn't even do the 50%.
Yeah, so the joint venture itself, when it's bidding on stuff, it can rely on past performance references of all the members.
Right.
But if you're out independently bidding as a prime contractor and you want to rely on this contract that the joint venture is performing, it's going to be a lot more nuanced. I mean, it's one, it's going to depend on whether the solicitation requires it, and two, it's going to depend on whether you were significantly involved in contributing to the project that JV performed. So it's unfortunately not a black and white answer, but if there's like a specific setup or scenario that you want to talk through, I'd be happy to chat offline with you as well.
Yeah, I mean, it's different tasks, so it's an IDIQ. So if we perform substantially on a task, we should be able to use it, right? Or at least try to use it. It's up to the agency to accept it, I guess, right?
Yeah, if there's a specific task order now, we're talking IDIQ contract awarded to a JV, and you've got an order that you performed, and you performed, the bulk of that order, and now you've got you're trying to use that task order specifically as a reference. I think you have a much stronger argument to make. But then again, it's going to depend on what the solicitation says. But I think you're on stronger footing in that circumstance to make the argument.
So here's another nuance. So a task order, that you cleared that up. I appreciate that. But CPARS is evaluated on the IDIQ. So can we use that?
The CPARs they are going to be associated with the IDIQ. They could issue, there could be CPARs for orders though, depending on whether the orders meet the certain thresholds. So if you've got a CPAR for the order, that's probably a CPAR you can rely on or should be able to rely on in the situation you just gave me the setup on. But if you're trying to take credit for the whole IDIQ's CPAR, that's a little bit more tenuous. I'd have to sort of talk it through with you a little bit more, but that's going to be a lot harder, especially if you're just a minority contributor to a joint venture that's got 3 or 4 members.
Yeah, it is. They only do it at the IDIQ level. So.
Right, and that's going to be a little bit more complicated. But of course, you would submit the task order number as your reference specifically. If that, if you were trying to make that clear, you'd say, hey, my reference is this task order. You wouldn't be trying to rely on the CPAR for the whole IDIQ. I mean, if you did, they might have some questions, but otherwise, if you limit what you're trying to rely on, that should hopefully, make things go in your favor.
All right, thank you. Appreciate it.
Absolutely. Are there any other questions, Edna?
Marvin has his hand up again, so I'm not sure. You can unmute yourself and ask a question if you still have a question.
No, ma'am.
Okay, great. Okay, there's no question on the question box. All
right, well, thank you so much, everyone, for staying with us this afternoon. We really appreciate your participation, and thank you to PTAC as always. You guys are a great organization. We really love working with you. If anybody has any questions or wants to talk about anything offline, this last slide here has both my contact information and Anna's contact information as well. We'd be happy to discuss any questions related to today's presentation or any other legal issues in general you guys might have.
All right, please make sure to contact us to make an appointment for one-on-one counseling service. If you have any questions, please email us at ptac@gmu.edu. And also, please visit our website and look at our calendar for additional courses, classes that you might be interested in attending. And thank you again, Sam and Anna, for a great presentation. And thank you, everyone, for joining us today. And I hope you have a nice day. Thank you.
Thanks. Take care, everyone.
Thank you.
Bye.